Hi, Charlie Sykes here. Happy Good Friday. I just finished doing my To the Contrary newsletter, which asked the question, how many of the people who wrap themselves in Christian identity and identify themselves as, say, Christ followers in their Twitter bios would have actually chosen Barabbas if they had the choice? How many of them would have reveled in the cruelty? Look, I know you know the story, but what I've done in the newsletter is asked you to read Matthew's account of the trial, the mob, the choice they made, and see whether or not it feels a little bit different. The freeing of the guilty, the crucifixion of the innocent, and the washing of the hands afterwards. Okay, but the reason I wanted to do this video was something else that's in the newsletter this morning. This amazing decision from the Fourth Circuit Court of Appeals rejecting the Trump administration's latest appeal in the case of the man who was illegally renditioned to El Salvador. Now, the important thing about this is, number one, it's a unanimous decision. But what really struck me is that this was written by a judge named Harvey Wilkinson. Harvey Wilkinson is 80 years old. He is a hardline conservative. He was appointed by Ronald Reagan. At one point, he was actually on George Bush's shortlist for the U.S. Supreme Court, but his conservative credentials have never been questioned, which makes it even more significant that he wrote this absolutely, exquisitely scathing opinion. And you know what I want to do? I want to read it to you. Now, you can read it yourself, and I would urge you to do this. The New York Times has a fantastic annotated version of it. But just sit back and listen to what one of the most conservative judges in America wrote here. It's difficult in some cases to get to the very heart of the matter, he wrote, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking, not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Goes into the details. Moreover, the government has already conceded that Abrego Garcia was wrongly or mistakenly deported. Why then should it not make what was wrong right? The clarity of this. If you've made a mistake, why are you fighting so hard not to fix the mistake? But then Judge Wilkinson goes on to write, the Supreme Court's decision does not, however, allow the government to do essentially nothing. It requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it should have been had he not been improperly sent to El Salvador. And it goes on to talk about some of the detail, including the definition of the word facilitate. Facilitation does not permit the admittedly erroneous deportation of an individual to one country's prisons that the withholding order forbids, and further, to do so in disregard of a court order that the government not so subtly spurns. Facilitation does not sanction the abrogation of habeas corpus through the transfer of custody to foreign detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would, here's the key, it would reduce the rule of law to lawlessness and tarnish the very values for which Americans of diverse views and persuasions have always stood. The executive, Wilkinson writes, possesses enormous powers to prosecute and to deport. But with power comes restraints. If today the executive, Donald Trump, claims the right to deport without due process and in disregard of court orders, what assurances will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And this is the heart of this case. And the judge is basically saying,
wait, if what you're saying is right, you could basically grab anybody and you could put them on a plane, send them to a foreign country, and then said, hey, yeah, he has no right of appeal. The courts have no jurisdiction. And what assurance would there be that the executive will not train its broad discretionary powers upon its political enemies? They're paying attention to what Donald Trump is saying and what he's doing. The threat, even if not the actuality, would always be present, and the executive's obligation to, quote, take care that the laws be faithfully executed, unquote, would lose its meaning. This couldn't be tougher. Today, both the United States and the El Salvadoran governments disclaim any authority and or responsibility to return Abrego Garcia. We are told that neither government has the power to act. The result will be to leave matters generally, and Abrego Garcia specifically, in an interminable limbo without recourse to law of any sorts. The basic differences between the branches mandate a serious effort at mutual respect, the balance between what judges do and what the president does. And then Judge Wilkinson cites President Dwight Eisenhower's sage example. Putting his personal opinions aside, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision in Brown versus Board of Education in 1954 to desegregate schools with all deliberate speed. Now Judge Wilkinson brings it back to this moment. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, the attacks from the Trump administration, to which by dint of custom and detachment, we can only sparingly reply. We can't defend ourselves. But the presidency, the executive, will lose much from a public perception of its lawlessness and all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. Wow. It is, as we have noted, all too possible to see in this case an incipient crisis. It doesn't say constitutional crisis, but that's what he's getting at. An incipient crisis. But it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that was in us while there is still time. Okay, so that is a stark warning. It is a stark definition of the problem. But Judge Wilkinson ends with basically a plea to the Trump administration, to President Trump. There's still time before you plunge us into this chaos, into this crisis. Read that whole opinion. It is an important document in our time, and I suspect it might be an important document in American history and in the history of the rule of law. Hey, thanks for listening. We do this because it is so important to remember that we are not the crazy ones.